I'm gonna go ahead and call this meeting to order. It is 1:30. It's the 4th of April, 2024. And we are in the Justice of the Peace Courtroom at the Grants County Courthouse. Roll call.
Commissioner Cheney,
Here.
Commissioner Casterly.
Here.
Commissioner Russo. Here. Commissioner Dukenyak.
Here.
Judge Gutsa.
Here, we've got a full court. Section number 4, citizens to be heard. Ms. Jackson.
Speaking on agenda item number 1, sir.
Right, okay. Well, you want to speak before it or? We're gonna move to it right now.
Okay, that's, we're moving right now. I'll speak now.
Yeah.
Standing.
Yes, ma'am.
Okay. We need a motion first.
No, she can speak on behalf of the one movement to the motion.
My name is Katie Jackson. I reside at 2205 Monkey Road. I'm also the Aransas County Republican Party Chair-elect. I am strongly against agenda item number 1 for several reasons. First of all, within the last year in the state of Texas, we've had 1.2 million new registered voters, none of them showing required identification. And it's not required. We also have the plank on the 2022 Republican Party of Texas platform, plank 242, which is prohibition of internet voting for public office in any ballot measure. And E, which is mail-in ballots must be requested and only granted to those that cannot physically appear in person. As we all know, over the last couple of years, there's been a lot of issues across the nation with voting. Right now, Texas sets itself up by not requiring identification. 1. 2, Texas does not allow electronic voting over the internet. 3, where I've been on website for Democracy Live, I do believe it's called. I have seen nothing on how we verify who that person is, what the actual electronic requirements are, what the operating system, do they need special software? What's the software? How do they get it? How do we make sure it's properly installed, et cetera, et cetera, et cetera. Looking at all of this from an outsider, from someone who has not heard the entire thing, it is not secure in my opinion. There's no guarantees. If your typical person that's going to vote absentee is elderly, they're not going to have an up-to-date computer typically. So they need to go buy a new $500 computer so they can load one piece of software so they can vote. It's now almost a poll tax. So I don't see how this is, I don't want to say legal because that's not the right word, how that's fair to everyone. I mean, I do understand for the disabled, especially like the blind and the hearing impaired, how this makes it easier for them to vote. But when it comes to absentee balloting, where's the proof of who they are? I can put any email in I want to. I've got 5 right now. No guarantee it's going to come to me. It's going to go to spam. Are they never going to find it? Those are all questions that would have to be answered before we even thought about possibly getting this program to run for the county. And that's all I have to say. Thank you.
Thank you. Do I have a motion for number 1?
I make a motion to disapprove authorizing the county elections administrator to apply for this, get my glasses. Apply for a federal grant with the U.S. Department of Defense Federal Voting Assistance Act. I'm opposed.
I'll second that.
We got a motion, we got a second.
I would also like to state that I heard from a few constituents who had concerns about this. I had a concern because of the tight time frame that we're discussing this, and then I guess the deadline is coming up maybe on Monday, I'm not sure. So I went online and I looked up the Democracy Live. It was created after the Hanging Chad situation in Florida. The gentleman who created it, other than the fact that he lives in Washington State, he's very active in the Seattle area, which is not necessarily a strike in his favor as far as I'm concerned. And it appears that the programs he offers are pretty much 100% funded by the federal government, especially since 2021. And I just think there are way too many questions, and what Ms. Jackson talked about, I also think those are concerns. We do a lot to make voting available to our registered voters here. Know that the people can come out to the curbside, the election clerks can come out to the curbside if that's required. People who need to use absentee balloting know essentially how to do that, and they've been doing it for years. I know things change, but I just feel like we do not need any more software programming to come in and mix with what the results are. When a lot of the states were using the, I think, Dominion software, it was found out that the owner of that, really, if you backtrack far enough, was in China. And I just don't think this is a good thing. I don't think it's a good thing for Vince County. I sure think it's a good thing for Texas.
I also went on internet, did some research. But one of the things was an MIT study that said that there was really no security in the system. But once the vote is cast, but I had some questions about that, asked Kevin. And I really wish we let Kevin speak to that, because Texas does require a paper ballot. And so if he would, could he speak to that?
Yeah, absolutely.
So this system would only be used for what we're already required to do by law at this point. So we are already required by law to provide a ballot electronically if a voter requests it using a federal postcard application. So it's only going to be used for military and overseas voters. That is it at this point. We are already required to provide those balloting materials to them electronically. This system would just make it easier on those voters to get that software, get the ballot itself, and complete it and return it. Second, state law does also require that those ballots be printed and mailed in, returned by mail. At no point would any sort of electronic ballot be counted or cast using that system. That option would not be available to our voters because it is not allowed by state law. There are states, yes, that do use it for voters to vote electronically and submit their votes electronically, but that is not allowed in Texas, and that option will not be allowed and available to our voters. So basically, this system would only be an electronic ballot marking device, just like what we have in our polling places.
It'll let them print out a ballot
Yes.
and they mark the ballot and they have to mail it in.
So they would make their selections electronically on the computer screen, but at the end, they would print out the ballot with their selections and mail that in.
Well, which would be counted?
The paper ballot. There's
Okay.
no electronic record that would ever get counted.
So if there's somebody out on the ship that's in Wisconsin and maybe just moved there or whatever, it's some other thing that would normally get them from being eligible to vote, felony, any number of things that could disqualify you, or an unregistered voter or an illegal voter and everything. If they get that accidentally or apply for it or whatever, what checks and balances are we going to have that would prevent that?
So they are required, these types of voters are required to submit an application for it. They're required to submit a federal postcard application that serves as a voter registration application and a request for that ballot by mail.
Would they send it back to you and you would look it over, or
Yes.
does they go to a federal registry or what?
They sent those applications to me since I'm the county early voting clerk. I review them, make sure they are complete and meet all the requirements of law. They are required to provide their social security number on that application and or their Texas driver's license number, just like they do for a voter registration application. And those do get keyed into our voter registration system, and it does get checked against DPS records and or Social Security Administration records, just like a voter registration application for any other voter in the state of Texas. So So this law, this program is not doing anything that is not already required for us to do by law, and it's not providing anything extra.
But the only thing the concern that I have with it is, you know, you got 5,000 people out in Afghanistan or Kuwait or wherever the heck they are, out on, you know, in the Pacific or the Atlantic. And there's really, I can't understand how you would have time to check them.
Well, regardless to the fact if we have this software or not, this is still going on a, you know,
so
daily
what-
basis, and
So
you know,
what's,
at the end of
what's
this
the
year.
downside? So what's the downside of not getting this? Is
Well,
it-
one, currently what we do is we send out an email to these voters with email attachments with their ballot and the instructions and all the paperwork they need to return their ballot. Emails are not exactly, in my opinion, a secure means of transmitting ballots. And that is exactly what the Department of Defense feels as well. That's why they're providing this grant funding, because they don't want to use traditional email. And there's also the risk that emails with attachments can get caught up by spam filters, and so that these voters never actually receive their ballots. And with this system, all we'd be doing is emailing a link to the voter who has requested that their ballot, that we have a request on file for, has requested that they receive their ballot by email or electronically. We would send them a link to this website. They'd go in and log in and retrieve their ballot that way. And that system would only the voters that actually have true requests on file would be able to get into that system. It would not be open to every single person at all.
And that email is obtained through their application.
Yes. The email that we send that information to is what is submitted on their application, requesting that.
And you currently receive that type of application now for somebody doing absentee.
We do. And we are required to do this electronically, send these ballots to voters by both federal and state law. So this is going to happen regardless of whether this grant gets approved or not. This is just changing the means of making it more accessible for our voters and making it easier on my office.
Is there a deadline for this grant?
So I was able to get an extension, yes, through the end of April.
Can we discuss further at a later meeting?
How many ballots do you currently send out annually?
Well, it does vary from year to year. These types of ballots, it does of course get higher in even numbered years because that's where federal elections are, you know, a larger turnout year. Right now, we have about 20 applications, but I do expect to probably have upwards of 50 to 75 by November. And, you know, literally me attaching emails, documents to, and sending out 75 emails takes a long time. Now, granted, not every single one of these voters that applies for this special type of ballot do request that their ballots be emailed to them. Some of them do actually request an actual mail-in ballot, but I would say at least 75% of these voters do request it by email. Because they are overseas, and it does take them a lot longer to get that ballot back to us.
Another question.
Yep. It's on vote. Motion on the floor is approved.
Commissioner Cheney,
Disapproved.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye to this.
Commissioner Dupnick,
No.
and Judge Gussom.
Aye. We got 4 yeas and 1 nay.
Thank you.
Item number 2. Just an update on the commissioners on the progress of the new courthouse. And we got Mark, I believe, the county attorney officer wants to take it.
Yes. So I'm certain that one of the things that we'll be discussing today is once again, the fire suppression system in the clerk's offices. So I wanted to talk a little bit about that first. And I wrote it down so I don't go too long. So we have talked about this for years now. Since the courthouse plans were even, before they even started being made. The requirements under the administrative code and the requirements of the elected officials in those offices have been made clear for years. Both to the architects and to the people who we have employed to build the building. And if everyone in this room is going to completely disregard the elected officials in this county and their lay opinions, then we should probably disregard the lay opinions of the architects and the builders also. So let's talk about the administrative code. Because apparently it's still not very clear to anyone that's making the decisions or building the buildings or making the plans. So let's talk about it. The Texas Administrative Code, Chapter 13, Section 7.163, which sets the standards for the courthouse and its permanent records. Not talking about the city buildings or any other buildings, talking about the courthouse, which we are building. It requires that the records be protected from fire, water, steam, structural collapse, unauthorized access of theft, and similar hazards. And that the records will not A, be exposed to direct sunlight, B, not be placed on the floor, and C, be protected by an operational fire detection system, or the facility must be in compliance with the local fire codes. So simply being within compliance with local fire codes is not sufficient. You are skipping over the first section, protected from fire, water, steam. So we're all smart people in this room. So let's use our brains. Logically, how would having a fire suppression system of water sprinklers protect paper from water and steam? We have all been aware for years that a waterless fire suppression system is what is needed in these two rooms of the courthouse. This should have been factored into the original plans and cost of the courthouse. There is no question about that. This administrative code was provided before the plans were even drawn, before the building began being built. And now I'm hearing that what should be done to fix the situation is that the county should buy waterproof cabinets to put the files in. So I ask, who is going to pay for these cabinets? How big are they? Will they even fit in the space alongside the other filing systems that already need to be there? Will the floor support the extra weight of those? Because we already know that those floors on the second floor were not reinforced properly to hold what already needs to be there. And why should we be ordering fireproof cabinets and waterproof cabinets to fix an issue that should not have been an issue in the first place? Thank you.
Thank you. Mark?
Yeah, so the first thing I'd like to mention is we had a non-compliance meeting yesterday with the contractor. And we were there along with the county, and we went over several outstanding issues that did not comply with the contract documents in several field reports, namely from Architects, who's the exterior component of the architectural firm. So in that discussion yesterday, we decided two things that are really important. one, that we do bilateral change orders rather than change directives, which the contractor wants a change directive to do the work so that he can wait to issue time and money at a later date, which, as you said, Judge Garza, is a blank check, which we do not agree with. We would like to see change orders take place so that we know upfront how much money and how much time is associated with any modification to the plans and specs. And then the other thing was,
Can I ask a question, Mark? Sorry. to
yeah,
interrupt.
sure.
Bilateral change orders, by that you mean what?
Both voted on and signed by the county and the contractor.
Okay, thank you.
The other thing was, we talked about several of the issues that are in that report. And one of the more notable issues is the distance from the soffit line down to the EPA system and the variance thereof. So what we did is we asked the contractor to supply the architectural firm with a distance from the soffit down to the EPAS. And they can't do that right now because they're pouring concrete on the north side of the building. We have a lot of the information in that document at this time, but we don't have anything on the north side, and I believe we're missing stuff on the western side as well. So that is going to be important to obtain that information. And I want to be with the contractor in the bucket truck, making sure I review what dimensions are taken and we get an honest description of what's there. So that's going to be one thing we take up.
And I believe they're gonna provide a mock-up of what it potentially could look like.
Right, yeah. So the ball is in the contractor's court. He is going to review this document, which has been passed out. It's the non-conformance with the contract documents letter, and it includes all the punch list items, or they're not punch list items, they're actually items of non-compliance with the contract documents. So he's going to answer that and come back to us. And I'm not sure if we determine an ETA on that, but we're looking forward to getting that information from him. As you know, any of this work, if it's rejected, he pushes his timeline further down the road, but we don't pay general conditions for that time because it's of his own accord to correct non-compliant work.
They expressed yesterday that they want to hurry up, and I guess they want to hurry up and get this done and quit wasting time. So I would imagine if that's their position, they would come answer that in a timely manner.
Right, and so we would like to go ahead and process a change order to do that attic installation, which I believe we tabled last time in the Commissioner's Court. So I want to check with Tracy and make sure we've got all the proper documents in place, and I'd like to maybe review that again on Monday.
When we find that out, can we find out why it costs twice as much more now than it did before?
Isn't that the truth? Yes.
I don't understand, is there a clause or everything, if the building architects or builder did not build it according to the requirements of state law, such as what the records say? I think that the records need to be protected in accordance with state law. Okay. I think the question is, are they being that or not? But I don't think they are. So I don't think that the courthouse is ready until that's a major issue. It's a major issue in cost. It's a major issue in the ability to function as a government, the keeper of important records and stuff. So I think what the county attorney has said and read straight out of the law was missed. I mean, nobody's addressed the fact that the state law doesn't say that you got to protect the records. There's been a question sometimes as to how we protect them, but from what Amanda just read out straight out of the law, it's pretty simple to things how you not to protect them.
Right.
And
I
to flood them
believe-
with water is a not protection.
I believe PGL is online to answer that if you guys want to respond, Paul.
Yes, I am. I'm on here. So this is Paul Bonnet with PGAL. Can you hear me?
Yes.
Yes.
Okay. So I don't disagree that it was brought up from the initial programming meetings that we had with the district clerk. And we do a lot of courthouses. We do a lot of record storage spaces. We've done several of them since 2013 when the item in the legislation was enacted. We do not we do not protect and haven't protected all of those facilities with a dry chemical fire protection system. And there are other options. In some cases, we don't put any sprinklers in those rooms at all. I believe earlier on in the project, maybe about a year ago, we looked into this and looked at removing any sprinklers from the rooms where the records are stored, not necessarily the office areas, but the rooms where the records were stored. And
Can I interrupt
Fire-
you there? Because I know what you're
Sure.
thinking, but the county clerk's office, the entire office has historical records. It's not a room. It's not a vault. And if you're talking about a vault, my room doesn't have a vault at all. That's my interruption, sorry.
Okay. I would just say, we do not have it in the documents. These systems are typically quite expensive. And, I personally did the Harris County archive space, which is huge, and it would be cost prohibitive for them to do a dry chemical fire protection system in that space. So I think that's generally why counties don't do it. I guess, our interpretation of protecting the records from water would be from flooding, having it be in a hardened building that's designed to withstand hurricane force winds that will protect the records. And we do have to protect them from fire. So
What's your interpretation of the word steam?
steam is not, well, having it in a conditioned space that's not going to be hot and humid.
What do you
Steam
think
isn't.
What do you think happens when the whole building's on fire and you're pouring water into the room?
And it's on the second floor, so it gets it from the bottom as well as the current room.
Mike Donahoe wanted to add something real quick.
Yes, Ms. Gardner, we have with us today, we have a certified fire inspector for the state of Texas. The city has entered into an agreement with a company to provide a state certified fire inspector, fire marshal. And he has visited these buildings. There are alternatives to and you don't want to put dry chemical in there either. They have what's called clean agents, and they are agents that are dispersed into the room that will suppress the fire. And it doesn't displace the oxygen, and it will protect the records. Now, those areas inside that room, they are pretty much sealed from the rest of the building. And I would like the fire marshal to introduce himself and talk about what he's looked at the system in the courthouse and explain what is there and what is not there.
Okay, first of all, good afternoon. My name is Joe Murray. I'm with Safe Built.
We just recently became the contracted fire marshal for the city of Rockport. I've only recently, in fact, I think it was today, that I've received all of the documents. These documents, be it fire protection systems, building plans, were all done by the previous company. So I've only had a day or two to even look into this related to what you guys are doing. So moving forward, we do not design systems, we review systems. Under my state license, that's what I have the abilities to do. So your higher design professionals, if they're wanting to make a change, they would have to resubmit the plans, then we would sit down and do the review based upon what those changes that they want to do. Now, I understand you have two different ways you can do that. You can either continue with the project, allow the permits to stay active while you're doing that, so that you're not delaying the construction of the rest of the building while the plans are being designed or redesigned, and then they go through the process. Or you have the other route where you stop the whole project. And at this point where we're at, it doesn't sound like we need to stop. We need to be able to work in conjunction with the existing construction while we're trying to take care of these issues. NFPA is very specific on records rooms. They actually have a specific NFPA that addresses this both on construction type, both on firewalls, what a vault is, what can be used as a vault. In addition, you have a clean agent or inert gas is another NFPA that you can bring involved with this as well. But they're design professionals who have originally submitted these plans and that they got approved. If that's who they're going to use again, they need to go back, revisit this based on your guys' questions and the additional state laws and administrative codes to address these issues, to give us the opportunity to be able to do a proper review. So we didn't do anything in relation to anything previous to this year. So that information is there. Once we get it, we'll sit down. As I say, I'll get my crayons out, start going through the plans, looking at the codes and figure out a way that we can provide fire and life safety with meeting the other administrative codes, because a lot of times codes are in conflict with each other. You have fire code that's now in conflict with an administrative code. So what carries more presumptive weight was the question you originally asked. That's what a design professional puts on paper. Then we do a review. HJ, which is City of Rockport, can make a variance if they so decide. So, if you guys have any other questions, I'll feel free to entertain or answer those
Would the
questions.
system that you're speaking of require that the air conditioning ducts in the vault room had some sort of automatic closure?
I'm not requiring anything. I'm just
No.
looking at the options that are available.
But with those sort of systems, if in order for them to turn on, the ducts need to be able to close like automatically?
You're gonna have certain systems that are going to have to be shut off, just like you would with any other fire protection systems that are in conjunction with other systems. So trying to correct one thing was going to affect things either upstream or downstream. That's why this company, PGAL, whoever they've hired as a contractor, the fire protection engineer or the RME or required managing employee from that company is the one that's going to be doing the submittal, and then we'll sit down and review it. Now, if we come into a point where we're in conflicts with codes and in addition timeframes, then that's when we're going to come back to the commissioner's court and the county judge to have them look at that. All right.
Now, could you use something just as like an Ansel system in the kitchen in a major restaurant or something? Because, that doesn't have any steam. It has no condensation. It's an inert thing. It's not hazardous to your health or anything like that. And as far as cost goes, I don't know how much that is, but those are locally, local installations, room specific, that would take a sprinkler system out or whatever. Would that satisfy what the clerks are concerned about?
So
That type of system?
right now, we're just having a discussion. Basically, what I say is a 50,000-foot overview discussion. Until the design professionals actually put it on a set of plans, I really can't speak to, will it meet code or will it not meet code, or will this be an alternative that will meet the code? Specifically, the code says that you shall provide an automatic suppression system. They don't say an automatic sprinkler system. They just say suppression. Suppression incorporates either a wet sprinkler system, dry sprinkler system, a wet or dry chem system, inert gas, halon, so on and so forth. So that word suppression covers a multitude of systems that could be looked at to be able to try to satisfy the administrative code as well as the fire code and provide fire and life safety with the preservation of the records.
May I say something?
Yes, ma'am.
First of all, thank you very much for being part of this to help. I'm so sorry. The reason, just so you know, a lot of building codes are gonna require water in there. And the way you get around that to meet the statutes, as I was told by the Texas State Library, is you put in another system that goes off at low temperature. You put a super high bulb on the water, you put another system in that goes off sooner. Again, we just need to meet the requirements. What we have now does not. And I realize this, I don't know when this is gonna get done. The county clerk has a very different situation than I do. I'm gonna send all of my permanent records to the Texas State Library until we can get a place taken care of for them. And then we'll worry about the rest of it later. But in the meantime, just so you know, there are codes that have to be met. I understand that. And if they have to have water, they have to have it. But then you have to have another system that's gonna protect the records from that water or steam. Thank you.
Yeah, the only thing I would add is we did do a little bit of research and we had our cost estimator brought us to do a cost estimate to provide the dry type system in that area. And I've passed out a copy of that estimate to you for your review.
Mark, did you look at any of the other type system? Other than dry?
The dry type covers several types of systems. It covers a clean agent and it covers a dry type system, much like what you were talking about, Commissioner Cheney. The one thing I will mention is the spaces in those rooms for this clean agent to work properly have to be sealed. That means no ceiling tile. It has to be a hard ceiling. No light fixtures like this. They have to be
explosion proof,
a completely impermeable light fixture.
Mhm.
All the ductwork has to be dampered. So when the fire alarm goes off, the damper shuts off so the clean agent doesn't go into the next space down the line in the air conditioning system. So there are a lot of modifications that have to happen to this space as it is right now before we can ever put the dry type system in.
But there's a risk to the employees, is there not?
There is a risk.
Substance very long.
That system there, that dry type system requires that you evacuate the space after it goes off. You cannot sit there and
Before it goes off. I'm sorry, Mark. Yeah, before it goes off.
yeah.
now, not having that system in doesn't prevent us from opening the courthouse. But it does prevent us.
There, my records, which is 90% of my job, can't go in that room with that vent system.
That's what I'm saying, that you can isolate areas that are limited in case, but you're talking about the exhausting thing, whenever you have a fire, you always shut the incoming, electrically, if you have a fire anywhere,
Yeah.
you shut the inlet air off immediately.
Absolutely.
And you never shut off the exit air.
But the ductwork, what I was saying is the ductwork has to have a damper installed that's presently not there. So that the clean agent is shut off from going into the room adjacent.
What he's saying is that since they didn't do it right the first time, now they're gonna have to redo it and charge us, probably gonna charge us more money is what he's saying.
Well, being that as it was, but that, anybody that's ever dealt with any type of floor space of any reasonable size knows that that's a fire code requirement. You can't have fresh air coming into a fire situation.
Right.
I mean, you just don't do that.
What
And you want
normally
as much smoke
happens-
gone as possible.
What normally happens is the fire alarm system shuts off the air conditioning system. So even though the ductwork remains open to that room,
Right.
there's no air pushed in it. This is a totally different situation. What I'm saying is there's another element that has to be added to the ductwork to shut it off directly above the diffusers so that clean agent the clean agent has to have a confined space to work. It can't bleed out into additional areas. Can't go into the door. The doors have to be sealed all the way around. Door sweeps on the bottom. I mean, we're talking a ton of work.
Mhm.
And that's why the price is over $2 million to do this.
And that's Broadus's conservative estimate.
Yeah, that's a very conservative estimate. Like I said, when somebody like Teal gets a hold of it, I guarantee it'll be more than that, much more.
Well, I have a question. Why are we going to be required to pay for that when it was sent to, in the very first questionnaire, JAL, that that's what was expected and needed?
Let's ask Paul.
Well, I think what I would say is, I think we could put together a meeting with the county clerk, the district clerk, Teal, Broadus, the design team to come up with what is an acceptable solution. There are other alternatives as the fire marshal said, there are other alternatives to a dry chemical, or I'm calling it a dry chemical system. Commissioner Cheney, you mentioned an Ansel system. That's a brand name for a what's an FM 200 system. So again, a dry fire suppression system. And we've used that before in places. We've used also a dry pipe system, so you don't have water constantly over the top of the space, things like that. So there are other alternatives that we can discuss and that are going to be less expensive. So,
Not exactly.
We
I didn't expect a true answer.
we also have the Texas Library and Archives Commission online.
They want to weigh in on anything?
Good afternoon.
Thanks for being on.
Glad to be here today. Just brief introduction. My name is Craig Kelso. I'm the director of the State and Local Records Management Division, and we are the division that put out Bulletin F4 TSLAC. And I'll let my other two colleagues introduce themselves as well.
I'm Megan Carey, the manager of the Records Management Assistance Unit. And I'm Catherine Hoffman. Oh, did you want to go ahead? Oh, sorry, Megan Carey, the manager of the Records Management Assistance Unit.
And my name is Catherine Hoffman, and I'm a government information analyst.
And we're just here to answer any questions that you might have, but that we can answer.
Well, rather than answer questions, could you provide us information? If
Sure.
you've been listening to the comments in here today, perhaps you have some wisdom you can shed on this situation?
Well, we're not. So the reason we have these, the storage standards are so broad is because we do leave it open to the interpretation of the local government. So we're not really able to speak for or against a particular method of fire suppression, but we leave that open. We leave that open for you to interpret with your legal counsel as to what is going to satisfy meeting the standard.
So can you tell us what the minimum required system is?
Looking at the standard and just the minimum requirement is that there is a fire detection system and that the floor is at least 5 feet above a 100-year foot floodplain. Those are the absolute minimum requirements within that. And then it is up to the local authorities to decide and determine what they want to, what constitutes protection from fire, water, steam, structural collapse, and unauthorized access theft. That's going to be different. And one of the reasons we made this so broad is because this has to satisfy for all 254 counties. We are not also authorized to inspect or look over requirements, or do we follow up? It's just we point to the the requirements and then allow the local constituents to figure out what is going to be best for them or how they would like to meet those standards.
So to clarify, there would be courthouses that do not have this fire suppression system that's currently being discussed. Is that correct?
I would say yes. For one, these standards only took effect in 2013 and were for any newer courthouses or renovations. So it's going to be a wide range throughout the state as to what is available for this in the record storage areas.
Thank you.
Thank you guys for being on. Commissioner, do you have any other questions? All right.
What does the state library use for a suppression system?
Pardon me?
What does the state library use for their suppression system on records?
For the state archives, the records that are in this building, we do have an aqueous gaseous system. At the State Record Center, we have a dry pipe system in the record stack area, and then in our vaults, we have a aqueous fire suppression or a gaseous suppression system as well. So we have 102,000 square feet of record storage space. And so in that space, which is for all records, not necessarily permanent records, we use a dry pipe system.
And can I ask what year was your building built?
What year was your building built?
Half of it was 1972, the other half was 1986.
In other words, they're not mandated by the 2013 legislation. They just do it because it's the right thing to do.
But there are alternatives.
Yes, there absolutely are, which
That's all we're trying to establish. There are acceptable alternatives to protecting records.
absolutely.
Thank
And I would also like to point out that when they're talking about the local authorities, they're talking about the clerks. This is an area of our jobs that isn't usurped by anything else. We've been completely open about this and saying what we need. I am 100% in favor of a meeting. I have asked for it, I don't know how many times, to sit down with everybody in one room so we can come up with something. Because we don't have time to wait. Like I said, I've made the decision, my stuff is going to go to the Texas State Library, so I know it's protected. And then whatever else happens, whether it's going to be another building built or they fix a vault room in my office for it to be compliant. And other than that, I mean, my solution for the temporary is the cheapest way to go for me and for the county. And it is the safest. So I am 100% of sitting down in a room with everybody and talking about this.
But I have never seen you come away from what you want. I've never seen it.
In this very room, I said, I am not saying we have to have a dry fire system. Said, no, ma'am, you can go back and look at it.
I'm glad to hear you say that.
Yes, ma'am. I said, whatever meets these statutes, I am all for it. If it's not a dry fire system, fine. I just need it to comply with the actual law.
I don't think what they just said it took to meet the statute is the same as what y'all are saying.
I want to say.
I mean, you could go back and ask them to verify, but
There's two different types of systems we're talking about. The dry type system is different than what he just mentioned. He mentioned the dry pipe system. Now, a dry pipe system still uses water. It's just not in the lines. And it activates by the fire alarm, and then it pumps the water into the line, and then it comes in the room. That's what he's got. So just want to make
but
that
he's
clear.
an older building.
Can I clarify that real quick? So the dry pipe system is also called a pre-action system. So what's safer about that is that it takes it takes both smoke and heat detection to set off the system. So that is why it's better than having water in the wet pipe system above your records all the time. It could leak, a pipe could break. So I don't think we've looked at that as an option here yet. The one option we looked at a year or so ago with the team here, at least the design team and construction team, was for the vault and or for the, I think the district clerk's vault, we looked at just removing any sprinkler heads and taking, adding some additional sheetrock to the walls to make it a higher fire rating for the room. And I believe we ran that past the city as well to see if they would accept that. And I think they would at the time, but it was deemed that solution was too expensive. And so we did not proceed forward with that.
The price we got from the contractor was exorbitant.
Well, we got to do something. And Paul, can you put your minds together and see what the most cost-effective way to beat this code or meet the statute?
Yes, and again, I think what I heard the state library folks say is that they require the records to be protected from fire, also from water, which I understand, and that can, obviously if if a wet fire sprinkler system goes off or a dry fire sprinkler system goes off, that is water, but it's kind of, in some interpretations.
Let's be clear. Let's be clear.
Let me finish, please. So in some it can be interpreted, and the state library folks said that it's up for interpretation by the authorities having jurisdiction, and we interpreted that. Obviously the hurricane affected the records previously, and I know that the county had to put forth some dollars to get the records restored. So having it in a secure building that's protected from hurricane force winds is an improvement.
The amount of money restoring those documents was $3.5 million just up to 1951. That still leaves 50 years of documents.
Let's be clear that I really respect the people from the Texas State Library, but their opinion does not overrule the administrative code. Their opinions are in addition to the requirements of the administrative code. So they are not stepping over the Texas law. They are just adding their opinions in addition to the state law. And your interpretation of the law may not be correct. And there are, I think, 2 attorneys in this room, and I don't think you're one of them.
Okay, fair enough.
All right, so.
Well, I think the easiest way to resolve this is to have a meeting about this subject, make sure that we all come to an agreement on how we can properly protect your records and your people, and figure out what is the least costly and best solution at this stage of the project.
Both have been saying it's their interpretation of the showing duty. Make sure the records are protected. So I would like it to be clear that if there's any meetings going forward, that those 2 are included, because I think they've been left out.
Yes. I would also like to see what some recently built courthouses have done for their record protection for comparison.
Commissioner, if you'll get with me afterwards, I have a bunch of information.
No, you can just present it to us. I mean, not right this moment.
It's up to you. It's up to you. If you want to see it, I have it.
Because I could not imagine we'd be having all of this conversation if there were really only one solution. It would be a done deal.
No, there's many solutions.
Okay,
It's just,
I would just be interested in what some other courthouses have done.
Mark, did you have anything else to pass?
That's all I've got.
Okay.
Thank you.
Commissioners? Any other questions about the courthouse construction? All right.
I don't know, Elle, do you have anything you wanna bring us up to date on?
No, Mark kind of talked about everything, the non-conformance. We haven't had a lot of movement.
I do have one more thing. Commissioner Casterline asked me to do a report of all the outstanding issues. That is ongoing. I've got that. I'm not finished with it, but I'll have it, I hope, by Monday.
Did you want to hit that schedule? Mike's.
I can talk a little bit about that. Mike is kind of the schedule guru, but so what that involves is this is a document that we had done by authorities that do nothing but schedule analysis. So they took the contractor's schedule and they took the native file. Now, the native file is different from a PDF. What they present to us in the pay applications and the owners' meetings as a PDF. And it kind of shows a graph of how they're progressing and when they're going to finish. Well, the native file, which is a document created by something like one of the software products that lots of architects use and contractors use to develop timelines, we were able to get several different versions of the contractor's timeline from them, their schedule. They sent us one back in, I believe it was around October of last year. Then they sent us a native file again back in December of last year. Then they recently sent us another version of the same file in around February. And so what we did is we sent it off to these guys and they take the file and they disseminate it. They look at where timelines intersect and they create what's called a critical path. And that critical path defines when the building's going to be finished, but it also links anything that has to happen before another activity can happen. In other words, you can't move in until the floor's down. Well, the floor can't go in until the concrete's poured. So those are linked. So this is how this schedule defines the critical path. So with that information, this group took that critical path and they observed some very odd incongruencies. And some of those included renaming tasks, like task 100 might be paint all the finish coats in all the rooms. Well, in the following schedule that they sent us, like 3 schedules I mentioned, the following schedule 100 might be install carpet. So it was very odd to have a contractor change the names and the definitions of each line item, because that ruins your critical path. You can't really tell what they're doing. They're monkeying with the schedule is what they're doing. And so that became very suspicious to us. And they took apart the timeline. And after they realized how much work is left in the basic scope of work, which is the brick, the EPIS, the roof on the tower, the brick on the tower, all these things that are basic scope of work that has not been caused any delay by the county or the architect or anybody else, it's of their own accord, their basic scope of work is going to go out to like July. So the Texas jail standards modification that we have to do to the project to bring several of the components up to the qualifications of the Texas jail standards involve new doors at the courtrooms and new frames. And it's about 5 or 6 different items that are really critical. And so that has a timeline with it. And that timeline, if it exceeds the basic scope of services, you count what happens from the basic scope to the end of the correction of the jail standards is how much time they're actually due. You don't give them the time that they've got basic scope to do, because that's of their own accord, you know? So anyway, after looking at the schedule, we've realized that they're due about 10 days, maybe 20. Now, that does not take into account, this report does not take into account any of the modifications that we have to do to the building to bring the non-compliance work up to speed. That adds additional time to the basic scope. So we may not open any time at all. And that's basically the end of the report.
I've got one other thing. The most recent courthouse that burned was Mason County Courthouse. That courthouse, I think, was 131 years old or something. And they're not really sure, at the last time I was involved in it, they really weren't sure what caused it, but they thought it was electrical. It would be interesting to see, with the fact that Mason is probably at least 100 years older than Rockport or Aransas County. How many of their documents were lost? Because there's pre-Texas Ranger documents in Mason. I think that and if there were not a lot of documents lost, how come? I think they just opened. They've been open about 6 months now, and I think the history would be great. But the thing that concerns me the most about the documents is we lose the documents, we lose the history up till today.
Yep.
You know, and that's important. I mean, you know, we have properties out here in Lamar and down in my area precinct that the lots are well over 100 years old. You know, they've been through 3 or 4 generations. You know, so if you, for some reason you had to go back since they were going to redevelop it, or you have to go back a long ways. We don't have those documents. There's hardly no way to do that. The documents are elsewhere. Some of them are elsewhere, such as with the surveyors and different things like that.
Right.
But birth certificates and death certificates and all that stuff, we're talking about a lot of money here to fix this issue, whether it's to do it in the courthouse or build another building for the storage or whatever it is. But we need to solve this problem. This is a one-time answer to a long historical solution. I have a good friend that is in Mason and is very knowledgeable of this, but I would suggest that the clerks, both of the clerks, contact their like at the courthouse and see what they did to help it out.
Commissioner, when that happened, and I've slept since then, but as I recall, the records were stored somewhere else. They weren't all in that building.
But had they been in there, what were they protected?
I've heard of through listserv, courthouses losing records. Strangely enough, most of the time it's because of water over the records. That's number one, and flood is number 2. It's 90% of the time it's water. It's not fire. But they literally put a call out to anybody who ever owned property in that county and said, can you please bring us a copy of your deeds? Now, since 1991 forward, everything is electronic. Most everything from the beginning of the county to 1951, once we finish this $3.5 million project, we will have electronic. There are scans of most things for those 50 other years. But just last week, we discovered from mid-March 1960 to mid-June 1960, there are 0 images. So obviously a couple of books got missed. We have had death certificates that are in Dallas for mold remediation that we don't have a copy of. We don't have an electronic copy of it. The most we can do for those people who are trying to settle estates or sell properties and all these other things is write out a certified copy of a fact of death. We know that this person died in this county, but we can't give them a death certificate. We've had a couple of people trying to get passports. We can't give them a birth certificate for the very same reason. These records are important to our citizens' daily lives.
Nobody is saying they aren't, Misty. There's not one person in here who thinks these records are not critical to the county and probably to the state and beyond. What we're saying is there may be other options, and you seem to be on a one-track path.
I mentioned the temperature bulb several times in several meetings. Pam and I, in our very first letter, stated 3 options that TSLAC presented. options. It was in our very first commentary.
Anything else, guys?
Have a motion to. Do we want to set up a meeting to get Pam and Misty and?
I'll have Al
do
set up a meeting
Okay.
with
Thank you.
Paul.
Yeah.
And
Move to adjourn.
5 seconds.
Seconds.
Commissioner Cheney,
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick.
Aye. Hi, we are adjourned. Thank you very much. Thank you guys for being here, City.